Um, just really grateful for you all to be taking this time out. I know we've been having a lot of really amazing presentations, and this one's super important. So thank you for being here today. And without further ado, I'm going to pass this over to Bob. Take it away.
Thanks, Janelle. I'm Bob Fleischner. I'm a retired disability rights lawyer. I worked for 45 or 50 years in legal aid organizations in Western Massachusetts, representing people with disabilities. So I am going to um, try today in this presentation to trace for you the disability rights movement in the United States, particularly in Massachusetts, but throughout the United States, with an emphasis on how the disability rights movement was impacted by the civil rights movement, particularly for people of color, and the movement for increasing the rights of uh, defendants in the criminal legal system through constitutional reform. I think that there are two distinct strands of rights activities in the United States: civil rights movement and the constitutional rights of criminal defendants movement, that had a huge impact on the development of disability rights in the U.S. So I'm going to take you through some slides, and then I think we can have some time for discussion if anyone has any comments or questions. So everyone's pretty familiar with the civil rights movement. This is a picture of a civil rights march, and you can see in the picture from the signs the kinds of things that the civil rights movement was looking for: decent housing, equal rights, civil rights for everyone. Uh, First-class citizenship is what's on all the signs. And the civil rights movement was broad. It had support of both people of color and from whites, and it was a nationwide movement led by people, of course, like Martin Luther King, whose birthday we celebrated earlier this month. At the same time of the civil rights movement, there was an interesting and very important legal movement going on in the U.S., largely through decisions in the United States Supreme Court in what was known as the Warren Court. That was the court that was headed by Chief Justice Earl Warren, who was appointed by President Eisenhower. That was a court that is really quite anomalous in the history of the Supreme Court in the United States, because it was a very liberal court. Historically, and particularly today, the Supreme Court is quite conservative, I think it's fair to say that overall, the court has protected the rights of the majority, the rights of property holders, and the rights of businesses over the rights of individuals, and particularly individuals of color. But in the 1960s, there were a series of cases that came to the Supreme Court of the United States based in the 14th Amendments. There are several prongs to the 14th Amendment, but the two important ones that we'll talk about are the right to due process of law. So you have a right to due process before you're deprived of your life, your liberty, or your property. And the equal protection guarantees of the 14th Amendment, which are that people are equal before the law and can't be treated differently based on race or religion or sexual orientation. And those rights have sort of grown up over the years, but those two parts of the 14th Amendment are really important to the growth of the rights of defendants. The kinds of rights that the court found were things that have become fairly commonplace today. The Miranda warning, in which the court held that person had to be advised of their rights during questioning if they became a suspect in a case. And so you see the Miranda warnings all the time on TV shows. They're very much implemented and implanted in our criminal law processes now. But prior to the Miranda decision, no such thing was happening. Same thing's true of the right to counsel. The right that criminal defendants have to have a lawyer and to have a lawyer appointed for them if they couldn't afford one, was as a result of a decision in the 1960s. And that's just an accepted practice today. So there was the theories that underlay the decisions of the Supreme Court in these 14th Amendment cases were important to the development of disability rights, and I hope to show you that as we move along. It's important, and I'm sure you all know this, but prior to the 1960s, in the United States, if you were a person with a mental disability, either mental illness or an intellectual disability, chances are you were in an institution. In Massachusetts, Massachusetts has the distinction of having the first mental hospital in the United States, Worcester State Hospital, which opened in the 1850s. Northampton State Hospital followed shortly thereafter. And the first institution for people with intellectual disabilities, then known as mental retardation or feeble-mindedness, which was at Fernal State School in Waltham. In this area, we had Northampton and Belchertown, which we'll talk about as we go along, because both are important in the development of rights for people with intellectual disabilities and mental illness, both in Massachusetts and in the United States. People with mental disabilities seldom attended school, or if they did so in separate classrooms. When I was growing up, there was a classroom in the basement of my elementary school, which is where the kids with what was known as retardation learned. That was true all the way through high school for me. Those were the lucky kids, in a sense, because at least they were attending school. Many other kids with disabilities were excluded from schools. And there were no such thing as ramps or any kinds of physical access for children who might be in wheelchairs or using other adaptive equipment. They just did not go to school. Or if they did, they went to special schools. If they were deaf, they might go to a school for the deaf. If they were blind, they might go to a school for the blind. But they almost certainly were not in regular public education. There were almost no community-based services. There were a handful of clinics that served some people who had mental illness. There were not many community-based services for people with intellectual disabilities, and there were almost no residential services. Even when I started working in an office, a legal office at Northampton State Hospital, representing residents of Northampton State Hospital, if we were able to get someone discharged from the hospital, most of the time they went to a rest home uh, or a motel. If you live in Northampton or have lived in Northampton, you may be familiar with the now demolished Shaw's Motel. That was the major place where people discharged from Northampton State Hospital went if they were from the Northampton area. If they were from the Springfield area, they went to a rest home known as Mrs. Laragione's. And there were no residential services of the type, there were certainly none of the type that Nonotuck offers. And there were almost no group homes. There were a handful of group homes in Western Massachusetts, but very, very few. So the rule for services for people with mental disabilities in the US was exclusion. People were excluded from services, excluded from schools, excluded from the community. They were isolated in institutions. They were segregated because those institutions were segregated, uh, often apart from the community. When Northampton State Hospital was built, it was outside of the city. Um, and they were congregated. It was just a place for people with mental disabilities or with disabilities. These were society's key strategies for dealing with people with mental disabilities. And they're the same strategies that were employed for people of color: exclusion, isolation, exclusion from voting, exclusion from day-to-day activities in the community, isolation in their own communities, not allowed to live in white communities. Redlining was the tactic used so that there were communities where the blacks lived or communities where Latinos lived. Segregation. Schools were segregated, particularly in the South, but also in the North. Uh, Segregation by schools, by trains, by public transportation. All of this until the Brown versus Board of Education decision in 1954. All of this sanctioned by the Supreme Court and congregated. Blacks were better off if they were kept together, just as people with disabilities were better off kept together so that they could be with their own kind. So the strategies for dealing with people with disabilities were the same strategies as society had for dealing with people of color. I'm going to talk about some of the strands and some of the things that happened that began to change things in the disability movement. Parents were the first people to organize, uh, particularly in developmental disabilities and later in mental health. Parents of institutionalized people had long been advocates for better conditions at institutions, often through things called Friends Association. So there was a Belchertown Friends Association, and there was a similar one at Fernald called the Fernald League, and there was one at Rentham, and there was one at almost every institution for people with at all of the state so-called state schools. And these associations would have some impact on conditions at institutions. Um, they had trouble recruiting in some cases because many parents were told when they institutionalized their children, and they often were institutionalized at a very early age, 4, 5, 6 years old, or sometimes in their teens when they became more difficult for families to handle without support. They were told not to have any contact with their children, that if they went to see them at Belchertown, it would just upset their children, and it was better for them not to go. I represented a lot of people at Belchertown, and it was very often see in the records where there was a recommendation from the medical staff, which was pretty minimum, or from a social worker to the parents that the parents not visit. And so the children and adults, as they grew into adulthood at Belchertown, and most of them spent their life there and at other similar institutions, they were quite isolated from their families. The next important growth in the intellectual and developmental disabilities area was the founding in 1953 of what was called the Association for Retarded Children. That's now known as the ARC. They've eliminated the no longer acceptable language in their title. But the ARCs were mostly made up of parents who began to ignore their doctor's advice to institutionalize their children and began to fight for community services for them and for the supports that they needed. Parents of people with mental illness, both children and adults, came later to organizing. And the first national association was the National Association for the Mentally Ill, now called the National Association for Mental Illness, which was founded in 1979. That's NAMI. One of the important organizing features of NAMI was that it was made up of parents who wanted two things: services for their children, and usually adult children, and they refused to any longer accept the blame for their offspring's disability. The psychoanalytic and Freudian movement often looked back to adults with mental illness, to their childhood, and to see how they were parented. And parents felt correctly that they were often blamed for the way that their children grew up, and for whatever mental illness they might exhibit in their childhood and their adulthood. So NAMI very much saw mental illness and continues to see mental illness as a biological disease, not as a result of poor parenting. In addition to parents, there are a number of other groups of people uh, who began to shine some light on what was happening in institutions. Senator Robert Kennedy, who was the senator from New York State at the time, in 1965, Kennedy visited the Willowbrook Institution, which was on Staten Island in New York. It was an institution for the mentally retarded. There were thousands of people warehoused at Willowbrook. This picture is Kennedy when he came out of Willowbrook and had a press conference, and you can see the concerned look on his face. Kennedy's reactions to the visit were widely publicized in the news media. He called the Willowbrook Institution a snake pit, and his disclosures were shocking to many people in the United States. But his alarms went mostly unheeded, at least for a while. Academics began to weigh in. One of the most influential pieces by an academic was a book published by Burton Blatt and photographer Fred Kaplan. Blatt was a professor at Syracuse University eventually. And Blatt and Fred Kaplan went into 5 institutions, they never identified which they were, and used a hidden camera and took pictures like the picture that you see on the side of this slide. His pictures were published in a 1965 book called Christmas in Purgatory, and then they were republished in Look magazine. Look was a very, very important magazine in the 40s, 50s, and 60s. It was a picture magazine. It was very much like Life magazine. And in the coverage of this, and in the book, and in the Look magazine articles, Blatt declared that there is a hell on earth. In America, there is a special inferno, the institution. He said that he and Kaplan knew personally a few institutions for the mentally retarded in the United States, completely free of dirt and filth and odors, naked patients groveling in their own feces, children in locked cells, horribly crowded dormitories, and understaffed and wrongly staffed institutions. And that's probably as good a description of these institutions as you're going to get. Academics also weighed in books. 2 of the most important books were a book by Wolf Wolfensberger called Normalization. Wolfensberger was also a professor at Syracuse University, and he put into a book what he called the principles of normalization in human services. Wolfensberger didn't invent these ideas, but he had a huge impact on mental retardation services in the United States and in Canada. This is a book published by the National Institute of Mental Retardation, which is a Canadian organization. And Wolfensberger as it happens, had a tremendous impact on the way that the mental health and mental retardation, intellectual disability services systems grew up in Western Massachusetts as well as throughout the country. Another book which had a profound impact was one by David Rothman. David Rothman is a historian, a medical historian. He taught at Columbia University School of Medicine. And he wrote about the discovery of the asylum. Title of his book is Social Order and Disorder in the New Republic. And it's a fascinating book on how asylums for people with mental illness grew up in the United States. And it turns out that a lot of Rothman's research was done at the Northampton State Hospital, which, despite all of its faults, had a wonderful system of keeping people's records. And the Northampton State Hospital records system helped Rothman write his book and develop his theories of how institutions developed in the US. The picture on the cover of the book, which you can see, I've forgotten what institution this is, but it's a typical design for an institution. It's with a center that was often called a panopticon and branches reaching out from it. And Wolfensberger, in his work, said that institutions always have a center, a nurse's station, and then dormitories reaching out from the nurses' station where everyone could see it. And Wolfensberger's interesting theory on this is that because the first services for people with illnesses were in churches, if you go back into medieval times and later into the Middle Ages and later, and Wolfensberger concluded that the design of the church with the altar at the center and uh, with the uh, with the sections of the church that approximated a cross became very much what grew up in institutions. And the nurses' station replaced the altar, and the dormitories replaced the cruciform form of the medieval church. And Wolfensberger also said that instead of the priest with the wafer, it became the nurse with the pill. Filmmakers weighed in. One of the single most important films was a film made by Frederick Weissman in 1967. Weissman just in the last month released his most recent film. He's been making films for what 60 years, and his films are all documentaries. I think he's made one film that's not a documentary. And his first film was a film called Titicut Follies, in which he was given permission to go into the Bridgewater State Hospital in Bridgewater, Massachusetts. Bridgewater is a facility of the Department of Correction. It's the Department of Correction's forensic mental hospital. It's one of the very few, maybe the only institution in the United States for people with mental illness in the criminal justice system that's run by the Department of Correction rather than by the Department of Mental Health. The film was shocking, and the Department of Correction, which had given Weissman permission to film, moved to ban it. And the Massachusetts Supreme Court, the Supreme Judicial Court, actually banned the movie. This is pretty unusual to ban a movie or a book through a court, but the Supreme Judicial Court banned the movie on the theory that it invaded the privacy of the people who were filmed in the movie. And allowed it only to be shown for academic purposes. So I remember when I saw this, you had to sign a form saying you were a social worker or affiliated with the university, and then you were allowed to see it. That ban was only lifted in 1991. So for some 20 some years, this movie was banned in Massachusetts. It's a shocking movie. Resulted in some reform of Bridgewater, but not enough. The conditions at Belchertown State School were exposed by newspapermen, and now we're going to talk our newspaper reporters, and we're now going to talk about. I'm not going to talk about the effect of the media, uh, particularly newspapers and televisions, on conditions. In 1970, the Springfield Republican ran a series by James Shanks. James Shanks was an excellent reporter who died quite young, um, but the series was called "The Tragedy of Belchertown," and it had a huge impact uh, on Belchertown State School and on the litigation that followed shortly after Shanks wrote his series. It was a tremendous piece of investigative reporting. Uh, at that time, um, mental retardation services were provided through the Department of Mental Health. So it was a Department of Mental Health facility at the time. The other big press impact particularly uh, on ID facilities, was a report by Geraldo Rivera. Geraldo Rivera is still around. You may have seen him on Fox News. Rivera snuck into the Willowbrook State School, climbed over a fence with a cameraman in 1972, and filmed the insides of Willowbrook and created a national scandal. At that time, there were 5,400 people locked up in utter filth and squalor at Willowbrook. And shortly later that year, the Willowbrook court case was filed claiming a right to treatment. And I'll talk about that in a minute. So this is a picture of Geraldo Rivera when he was a younger man outside of the Willowbrook School. We've talked about organizing by parents, intervention of, or the interest by some politicians, academics, uh, newspaper and TV reporters. And the last group of organization came from people themselves. And probably in the mental health area, the most important development was the publishing by Judy Chamberlain, who's pictured here, of a book called On Our Own in 1979. And Judy formed the Mental Patients Liberation Front in Boston. You can see that Judy and her allies drew their name not from the most radical parts of the civil rights movement. On the ID side, uh, self-advocates began to come together, and this is a poster from a first national conference of self-advocates becoming empowered. Legislation began to address some of the problems. It was early legislation going back to 1963, signed. This is a picture of Senator Kennedy and a group of mostly men at the signing of I think there's one woman in the photograph, signing the Mental Retardation and Community Mental Health Act in 1963. You probably know that the Kennedy family, one of Kennedy's sisters, was a woman with intellectual disabilities. Because of her intellectual disability, she was lobotomized and lived in an institution in Minnesota for most of her life. Some of her sisters became very involved and very important in the disability rights movement. This legislation was very important. It was the first legislation, national legislation, to address some of the issues. It created some community programs. It began the move away from institutions, but it was a slow movement. Let's switch to the courts. As I said, the Warren Court began to expand the rights of minorities to equal treatment, beginning with the Brown versus Board of Education case in 1954. And then to expand the rights of people who were arrested and during their trials. Miranda, Escobedo, other important cases. Meanwhile, civil rights advocates marched in the streets, often at significant personal risk. The disability rights movement began to adopt the tactics of the civil rights movement. This is a picture of a demonstration outside the annual American Psychiatric Association meeting in the 1960s. And the second picture, the black and white picture, is a picture of a group called ADAP, which is largely a group of people with mobility impairments. You can see here the leaders of this march are people in wheelchairs. ADAP was a particularly effective organization. ADAP members frequently chained themselves to, for instance, the gates outside the White House or outside of Congress to make a point. They were often arrested, and they felt that passive resistance, which is very much part of Dr. King's theories of how to move the civil rights movement, would also move disability rights forward. So this is an example, I think, of Mental Patients Liberation Front, ADAPT, and other disability rights movements adopting the tactics of the civil rights movements. Back to the courts. One of the things that grew out of the development of civil rights for people involved in the criminal legal system was a series of cases attempting to advance the rights of institutionalized people. This is the first generation of cases which are discussed in this slide. The first cases that were brought were cases attacking involuntary institutionalization. So the attempt was to try to close the front door to the institution. In these cases, which attacked mostly civil commitment, and you should understand in probably about 2/3 of the states, people with intellectual disabilities can be civilly committed in the same way that people with mental illness can be committed. That's not true, hasn't been true in Massachusetts since the 1970s. So most people in mental hospitals in Massachusetts are there involuntarily. They've been committed by a court. And that's true throughout that was true throughout the United States, or placed there by their guardians or by family members. The first group of cases were attacking the processes for involuntary institutionalization by importing the rights of criminal defendants into the civil commitment process. So the early cases said you had a right to be told that a case was being brought against you to commit you to an institution. That seems fairly fundamental, but that didn't necessarily happen. You had a right to know what the basis of the civil commitment process was, on what basis you were being the state or the hospital sought to commit you. You had a right to attend the hearing. You had a right to cross-examine witnesses against you. And eventually, you had a right to an appointed lawyer if you couldn't afford a lawyer. These cases were successful in the sense that they created a more fair process, but they actually had very little impact on the number of people who were committed. So the institutions remained about the same size. Second set of cases was lawyers began to say, and their clients began to say, well, we can't stop. We haven't been successful in keeping people from getting placed in institutions. Let's at least try to make the institutions more humane and attack the awful institutional conditions. And, and the theory behind this was to create a right to treatment. So that if you're placed in an institution, you have a right to get treatment. The basic argument was known as in its most simplified form, was known as what is a quid pro quo argument. So the state was taking away your liberty without charging you with a crime. The only other group of people who could have their liberty taken away and placed in is the group of people placed in prison because they committed a crime. So if the state was going to do that, it's going to take away your liberty, put you in an institution, it had to provide, in exchange for that, the state had to provide you with safe conditions of confinement and with treatment. If the purpose of the institutionalization was because you couldn't take care of yourself or you needed treatment, the state had an obligation to provide it to you. Courts mostly agreed with these cases, but many of them they had no impact on admissions or discharge. They did create things like individual service plan processes. Some of the cases required the institutions to provide toilet seats on toilets, to provide toilet paper, to have social workers, to have doctors who actually had licenses, things like that. But they were really not successful in creating good institutions, if that's even possible. And they did nothing to impact the admission or discharge of people from institutions. The cases against Belchertown State School, Fernald State School, and the Munson Developmental Center were right to treatment cases. The Belchertown Friends and the Friends of Munson filed cases, and the Fernald League filed cases saying that these institutions are horrible places and the state has an obligation to fix them up. The second generation of cases took a very different path. And again, using the theories that had been developed in the 14th Amendment cases and in some First Amendment cases. The lawyers in these cases said that if the state is going to take away your liberty because you need treatment or because you have a disability, it can only do it in a way that's the least restrictive way to accomplish the purpose of putting you in the institution or of providing you with services. And these cases were mostly brought against ID facilities, and they were generally successful, although they were generally successful through consent decrees, through agreements, settlement agreements, not through court orders. So community programs, mostly group homes, were created, and people were moved out of institutions into group homes. The cases at two other in Massachusetts, the cases at the Rentham and Dever state schools combined right to treatment theories like we got to make a better institution and the right to community-based treatment. Eventually, all five cases, Rentham, Dever, Fernald, Munson, and Belchertown, were combined before one judge, Judge Toro, and the facilities slowly began to place people in the community programs, and eventually, after decades, to close. Uh, One of the biggest impediments to the success of these least restrictive alternative cases was strong, virulent community opposition to having people with mental disabilities living in communities. Group homes provoked the biggest kickback because blowback because they were so obvious. Uh, but there were demonstrations. There was one placement that came out of the Northampton State Hospital consent decree was in the Indian Orchard neighborhood of Springfield, and it was a small group home was being created on one of the streets in Indian Orchard, and the neighbors put up barriers on the street. They picketed the house. They yelled things at the people who were moving out of Northampton State Hospital into this group home. It was a very, very nasty confrontation. What ended the confrontation was when a group of nuns from the Sisters of Providence and the Sisters of St. Joseph began a prayer vigil outside the house in support of the people who were moving in, and the neighbors backed off, not wanting to cross the nuns. The case against Northampton State Hospital and Metropolitan State Hospital cases that I was involved in were strictly least restrictive alternative cases, and the goal was to force the state to create community-based mental health services. This is a picture of the old building at Northampton State Hospital, which has been torn down. The Northampton State Hospital ended in a consent decree in 1978, and the state hospital finally closed in 1993. There was other important litigation. Excuse me. There were a number of cases brought initially by ARCs, but then later by other groups to create a right for children with disabilities to have a free, appropriate, and integrated public education. These cases were successful and were eventually followed by legislation. Massachusetts was the first state in the country to have special needs right to free appropriate public education in schools in something that was called Chapter 766. A couple of years later, Congress set a national standard for this. There were also a number of cases brought by lawyers initially from the Mental Patients Liberation Front to create a right for people to make their own decisions uh, about treatment. They were called right to refuse treatment cases. And the most important one of the most important in the country, and certainly the most important in Massachusetts, is Rogers versus the Commissioner of the Department of Mental Health, which is a case which still reverberates today through Rogers orders. Then the Supreme Court eventually, as it usually does, weighed in. And the court had changed by the time these cases got to the Supreme Court. And it's a much more conservative court as it remains today. Not quite as conservative as today, but still conservative. The right to treatment idea got significantly narrowed in a case called Romeo versus Youngberg. Nicholas Romeo was a man in an institution, Pennhurst Institution in Pennsylvania. He spent almost all of his time at Pennhurst in restraints. The parties in the Romeo case agreed that Nicholas Romeo would never leave Pennhurst and that he had a right, so that since he had to be there for his entire life, he had a right to safe conditions and a right to treatment. The Supreme Court defined the right to treatment in that case as saying that people have a right to be free from unnecessary restraint, and that the state must provide such treatment as is necessary to reduce the need for restraint, as is determined by the state's medical professionals. The Supreme Court also begrudgingly said that people in institutions, in mental retardation institutions, have the rights to the same sorts of safe conditions of confinement and medical care to which prisoners are entitled. Pretty low standard. So the right to treatment in the Youngberg case was narrowed significantly from what it had been in the earlier right to treatment cases. Nicholas Romeo, by the way, was soon discharged from Penhurst despite the promise that he'd stay there forever. It also became clear in these cases that the least restrictive alternative could not sustain itself as a theory for closing institutions. Some state courts, including the Massachusetts Supreme Judicial Court, have recognized the right to treatment in the least restrictive alternative, however, and that right exists in our civil commitment laws. When the Supreme Court failed to come through, Congress finally did. In 1988, Congress passed the Federal Fair Housing Act amendments, which guaranteed people with disabilities the right to be free from discrimination in housing. And then in 1990, the remarkable Americans with Disabilities Act, the only civil rights law passed during the Reagan administration, eventually signed by President Bush. It's a very important anti-discrimination law that guarantees people with disabilities the right to be free from discrimination in state services, public accommodations, and transportation. Then in the Olmstead case, later in the 1990s, the Supreme Court upheld what was known as the integration mandate, which was part of a Department of Justice regulation, that said that under the Americans with Disabilities Act, unnecessary institutionalization is a form of discrimination, and that people who want to and can be, in the words of the Supreme Court, handled in community, have a right to be discharged and not be institutionalized and to be provided services in the community. So that's where we are now. And what can we expect in the future? Wherever there's progress, there's pushback. There are groups pushing to reopen DD institutions and state hospitals in Massachusetts. In fact, there's almost certainly been a growth not of state hospital beds, but of psychiatric beds in Massachusetts over the last decade. Some families fought very hard to keep Fernald and other state schools open. Belchertown closed with the support of the Belchertown Friends Association, but other state institutions have fought. Have been the closing of those institutions have been fought against by some parent groups. There are bills pending in Massachusetts and Congress that would make it easier to institutionalize people, would limit the right to make your own choices about your treatment, would expand the use of guardianship, and would amend the ADA, particularly in areas of access to services and to stores and ramps and so on. There are bills that would expand rights, things like the supported decision-making bills and others. Using what it's learned from the civil rights movement, disability rights movement is now sophisticated and well organized. So despite the pushback, the future is bright, but vigilance and continued fighting for rights is a priority. So I'll stop sharing my screen there, I think. There we go. And welcome any comments or questions if anyone has any.
No, that was great. Thank you.
Thomas, I see a hand up. Way to go.
Great, thank you. And thank you so much for your time. Always great to hear your presentation and really, once again, thank you for the education as well. You had said, I know Massachusetts was the first state, sorry, I have a little second, okay, to become spearhead the disability rights. What was the second? I know you said Congress enacted laws. Did that just basically mean that all states had to follow suit, or how did that work?
Yes, in the and this is in the right to a free and appropriate public education. There was a lawsuit in Pennsylvania called Park versus Pennsylvania, I think. Park stood for the Pennsylvania Association for Retarded Citizens. And in that suit, the ARC in Pennsylvania claimed that their children were being unconstitutionally excluded from an education. The courts have said consistently that there is no constitutional right to education in the United States. But if a state provides education, it has to do it in a way that treats everyone equally. And so what in the Park case, what the federal court said in Pennsylvania was that children with disabilities had a right to attend school just like anybody else, and that they needed the kinds of support, and they had to be provided the kinds of supports that were necessary to allow them to do that. Shortly after the Park decision, there was another court, I've forgotten where, that held essentially the same thing. But then Massachusetts passed Chapter 766, which was the first legislation in the country to establish a right to free, appropriate public education. And Chapter 766 was the model for the law passed by Congress, which was known as 94-142, which was the right, which has been amended several times since then. But in 94-142, Congress said that if a state takes funds from the U.S. Department of Education, it must conform its schools to 94-142. So it signed it to what's called the spending clause of the Constitution, and that became the law of the nation. So every state since then has its own laws, but the federal law is the minimum that a state has to provide. So Massachusetts was the first, and we should be proud of that.
Thank you, Bob.
Yeah, Jessica.
This is actually coming from Tammy.
Oh, hi.
Hello. First of all, thank you once again for sharing your vast knowledge with us. I always learn something when you're here. I am wondering if this is a presentation that can be given to our caregivers at some point, because I think it would be extremely valuable for them to hear more detail about the rights and how they got developed. I mean, we tell them, of course, and we share as much as we know, but something like this would be highly beneficial, in my humble opinion.
Well, I'd be happy to do that. I think you're right about this. When the Center for Public Representation in Nonotuck finished its first or second year of the supported decision-making pilot program that we were running, then we had a dinner for everyone who was involved in it. The parents and the family members and the supporters and all of the Nonotuck, the people who have Nonotuck service recipients. And one of the things, and we did a presentation, not this presentation, but we did a presentation on the development of supported decision-making around the world. And I can't tell you how many people came up afterwards and said, we never understood we were part of something both so large and so revolutionary. And I think we all, if we lose sight of our history on this, and lose sight of what's happening in other places, we lose sight of it. It's a good way to feel involved in something that's bigger than just what you're doing. And I would change this presentation a little bit to explain the movement away. The solution to everything in these right to treatment and least restrictive alternative cases was group homes.
Right.
And all of us who litigated these cases, if we were doing them instead of in the 70s and 80s, if we were doing them in the 2000s, that would never be the remedy. We made so many, we knew so little, and we relied on professionals to advise us who knew a little bit more than we did, but not a lot. that we didn't know how to provide services in the best way. And so the movement from group homes and from day programs and from segregated settings in the community to the kinds of programs that you provide and to real work is an important development that if I did this or someone did this, could build into this, because it would have more meaning, I think, for the service providers that you have, to show them part of that movement. We haven't gotten rid of group homes. They're still a big
not at
deal.
all.
And in much of the United States, there are still things called adult care homes in New York City, which are supposedly community programs with anywhere between 50 and 200 people living in them, with curfews and with group. Yeah, it's hard to tell that this just isn't a slightly smaller institution. But so yeah, I think it's a good suggestion. Or if the leadership at Nantucket thinks it's a good suggestion, then I'd be happy to do it, or find someone who could do it for you.
Thank you.
Yes. Will this training be available?
Was this training being recorded by any chance?
Yes.
Perfect.
Thank
Okay.
you, Janelle. Thank you,
Thank
Bob.
Rob. He reminded me to record.
Yeah, Rob.
Okay. I don't have much more to say. That's everything I know.
We have one more hand raised.
Oh, Dan. You're mute, Dan.
I always do that. I just want to thank you for your presentation. You know, I can sort of give testimony to the accuracy of it. Not that anybody was doubting that, because I met Judge Truro back at Munson State Hospital back in '75, and so I just appreciate your presentation, and I think it is important that I think as those of us getting older, Bob, you and I, that we actually can share this history with younger folks so they know kind of the history it does inform us, and it also cautions us, because it's always about where does the power lie in any system, and if you want to give the power to individuals, it's a real important endeavor, and I appreciate your clear rendition of what that history was. So I appreciate it.
Well, thanks. Judge Toro was an interesting
Yeah.
judge. He controlled these cases, or he oversaw the 5 MR cases, which are known as the 5 MR cases, for decades. And I mean, and at one point, we were involved off and on in this, that the cases that, a little into the weeds, but the cases at Rentham and Dever became very problematic, because, as I said, they were both a combination right to treatment and discharge cases. And so there were 2 plaintiffs. The ARC was a plaintiff and the parents groups were plaintiffs. And over the years, they split. The ARC wanted people discharged, and the families wanted the conditions improved. So we wound up representing the ARC in those cases. And what this all leads to is, at one point, the families moved to keep Fernald State School open. And when we had a hearing in front of Judge Turo, he walked into the courtroom to a standing ovation from the parents. And he took his robe and spread it like this, like he was some sort of Greek god or something.
No kidding.
He was a very good judge, but he certainly had a very high opinion of himself. Which I
just had a
think
brief interaction with him, and that rings true. That rings true.
Yeah.
Thanks for that.
Can be an occupational hazard. Some judges, not all of them. Right.
Right. Back
Grayson.
to power, right? Yeah. Who has the power?
Yeah,
Hey
Grayson.
Bob, how are you?
Good.
I was just curious if, following the movement that where the conditions of these institutions came to light for the public, was there any kind of legal action pursued against the staff, or were there not really laws in place to do that?
There were there were occasionally were damage cases against institutional staff, but they were infrequent, and there are a number of reasons for that. One is that nobody knew what was going on in these places. There was very little oversight. Our office at Northampton State Hospital was one of the very few in the country that had the kind of access that we had to the state hospital. So there weren't a lot of people looking at what was happening. Secondly, as a practical matter, and I hope you find this offensive, because it is, lawyers would not bring cases on behalf of severely disabled people who were hurt because they couldn't prove damages. There was either a belief that they couldn't feel pain, that they didn't understand what happened to them, or there was no way to measure the extent of damages. Typically damages in a personal injury case involve things like loss of income. Nobody had a job. Medical expenses. They weren't paying any medical expenses. It was all taken care of or not taken care of by the state. And juries were very unsympathetic to people with disabilities. I can remember a district attorney, we tried to get a criminal charge against a staff person for something once, and a district attorney screaming at me that I'm not bringing that retard into my classroom to testify, into my courtroom, sorry. So there weren't a lot of that. Also, there were cases in which one of the problems with the discharge cases in particular were the staff were going to lose their jobs. And so there was often a lot of pushback from the unions about discharging people. Understandably, people were worried that they were going to be out of work. And so that became a feature in many of the cases in ways that it was very difficult. So in the Northampton State Hospital case, the Department of Mental Health did a very good job in finding jobs for people and trying to reassure them that they weren't going to get left. There would be jobs in the community, but the institutional staff said, we don't work in the community. You community people don't pay enough. We lose our state benefits. We lose our retirement, all of that stuff. So they're very complex relationships with staff. Edward, did you have something?
Yeah, it was a similar question to Grayson's, and you answered some of it, but along those lines, I was wondering, because the institutions are owned and run by people, just like prisons are institutions, which means they also create a profit. And I was wondering if there were any legal or financial repercussions for the people who profited from the abhorrent neglect provided to the people when they were deemed unfit and closed.
No, not really. The institutions used to be much more profitable. Northampton State Hospital, in probably until the early 1900s, didn't cost the state a dime. Totally self-sufficient.
So
all
essentially white collar crime.
Yeah, yeah. But the difficulty with that is that, despite that, if you put aside the conditions, the state administrators who were running the institutions for many years, this was the standard of care. This was the accepted model of how you cared for people with disabilities, is you put them in an institution, and you should provide them with good stuff. But
yeah, I understand that concept, and that maybe in the time frame they could say they didn't know any better, but that just reminds me of what the police say, which is ignorance of the law is not, it's that's your fault, not ours. And I just was wondering if the people that profited from running institutions and treating people like that were held accountable either financially or legally. That's all.
yeah, I think the answer to that is no.
No. All right.
Rob?
So it's not so much a question, more of just kind of a comment, and really just kind of this isn't the first time I've kind of been a part of these types of trainings and kind of viewing and digesting a lot of kind of with some of the historical context of our industry and what we're kind of working with. And although it can be pretty hard to kind of take a look back and look at these things, it does kind of put a lot of perspective into the things that we're working with now and some of the more positive things that we're working with, like our supported decision making, our positive behavior support plans, and even our plan to enhance quality of life. And it's kind of inspiring to really think about how we really are part of like a bigger, larger conversation about how we care for people and how we're constantly continuing to grow. And it's just a little inspiring to really kind of think about that kind of stuff and honestly focus on what we can kind of continue to improve and provide better care for the people we support. And it's a positive trajectory, and it's just something nice to kind of, even though it's pretty unpleasant to look back, but to see where we are now to where we were is very good.
Yeah, I'll end with this. I think that's a really good point. And I think the single biggest difference between the history and now is that the voice of the individual and the voice of the person is heard and is credited. And that's an enormous difference. And a lot of that, the credit for that goes to the self-advocate groups and to groups like the Mental Patients Liberation Front, where people who said, my voice counts, nothing about us without us, which was Judy Chamberlain was the first person to use that. And that's a absolutely profound difference in the way that services used to be provided. There's still a long way to go with that, but it really changes the service system enormously. So I know it's time for you to get back to work or have lunch or whatever. So thank you very much. And it's always fun to do these and put this together. So
Thank
Thanks,
you.
Bob.
Thank
Take
you
care,
so
Bob.
much.
Thanks.
Thanks.
Appreciate all you've done.
Thank you so much.
Thank you
Okay.
so much.
Okay, bye-bye.